Thank you, Justin. Good evening and good morning, everyone. Depending on where you are and when you are watching this webinar, we're going to record this video and put it on BCLT's CLE platform and our YouTube channel for review at a time convenient for you. So my name is Hao Yuan. I'm a lecturer at Berkeley Law, co-director of Berkeley Asia IP and Competition Law Center. Today, I'm very pleased to have Mr. Binxin Li, the co-founder of LeanWill law firm, with me to talk about the IP protection landscape of China today, especially in the fields of patent and trade secrets. I've known Binxin for years. He's a proud Berkeley graduate, LLM graduate in 2014, right?
Correct.
Yeah.
Yes.
So, in my opinion, Binxin is really one of the top IP attorneys in China, and always striking me with his great professional skills, his integrity, and his distinctive personal style, if I may say so. I find that Binxin is always able to provide both practical and creative solutions to challenges while mitigating risk in his practice. I'm not going to read his bio word by word given the limited time, but I do want to highlight that Binxin has nearly 20 years of extensive experience in Chinese IP, and his clients include both multinational and domestic companies across a wide range of industries, including healthcare, telecommunication, consumer goods, energy, entertainment over the years. His expertise also encompasses various IP issues covering filing, portfolio management, litigation, and technology transfers. Many cases I know Binxin represented were selected by the Chinese Supreme People's Court and the lower courts, as well as the CNIPA, the Chinese IP office, as top 10 cases or representative cases during the past 2 decades. And some of the cases Binxin has been involved with are literally shaping doctrines, IP doctrines in real time. So before co-founding LeanWill law firm, Binxin was the IP co-head at Baker McKenzie Fenxun Joint Operation Office. Later, he became an equity partner at Angie law firm. And recently, he brought his vast experience, expertise in the past two decades and co-founded this promising IP boutique firm called LeanWill in Shanghai. And I'm very pleased to see that despite his young age, LeanWill has begun to attract significant attention in China and internationally too. So without further ado, Binxin, why don't you walk us through the IP, especially patent and trade secret protection landscape of China today first? The floor is
Thanks, Dr.
yours.
Mao. Thanks. First, thank you for the invitation, and it's always my pleasure to be back and share a couple of the stories and experience with our colleagues and community members. Um, I do remember a couple years ago when we have a topic and sharing discussion regarding China IP protection. I do believe at that time, China just became the second largest economic entity,
Mhm.
and we have been exploring, what does that means to the industry and to the IP protection environment. So I think as a guru, a couple of our guessing become true and it's become more and more like a common practice in the society. So I think now is also a good time for us to review again
Mm.
on what's going on in China and let's make a guess on the future as well. So this is actually my topic for today's presentation. I will talk about the present and the future for China protection. Let me go a bit. Um,
Good.
Before we dive into the details of the topic, I want to take a couple minutes to introduce our firm. And as Dr. Hao mentioned, we are a IP boutique law firm and cover various services. I do want to spend a couple of the seconds on the representative cases, which is actually also a reflection on the involvement of IP system in China. So we got a premium injunction for process patent in China a couple years ago, and we also returned the client to get a very first infringement judgment actually overruling CNIPA's invalidation decision regarding the claim construction. Um, and we got the very first patent linkage cases in China, which is another very interesting story to share. And we got a benchmark cases regarding government central procurement for pharmaceutical companies just a couple of years ago. And just recently, we also got the first judgment to actually recognize combo use for a pharmaceutical patent. Um, so things like that, actually, I think is demonstrate the involvement, again, demonstrate the involvement of our IP environment. So I would skip this one. Just just verify, the picture and profile picture is pretty much the same. No Photoshop.
Haven't
Um,
edited at all.
so thanks. So before we talk about IP issues, I do want to draw the audience to a relatively bigger picture on what's going on about China, about the market. The reason I want to talk about it because I think overall the market is the powerhouse for innovation and also for competition. So that's actually the starting point for everything, and probably gonna explain everything what's going on, everything about what's going on in China regarding IP. A couple of things I don't think it's gonna be news, any news to the audience. I think China start to transit from the tech follower to the innovators. As you can see in many of the industries, including pharmaceuticals, including robot and AI as well, we start to see more and more startups and the innovative stories generated from the China land. So a couple of the driving factors, I think, as we mentioned a couple of years ago, which actually the fuel for this transition, we have a growing talent pool who actually leading and become the founder of these startups in various industries. And we have a very sophisticated and comprehensive supply chain, and which leads to the high productivity in many of the industries. And that means once we have an idea, you can realize it in very quick speed. And another thing that we have a huge population and huge market. That's actually reflect a testing field for various ideas, including AI, including pharmaceuticals. And all of this actually become the driving force for the innovation. I think the Economist magazine, there is one chapter actually particularly address the innovation regarding China. I think they gave a quite fair analysis about what's going on with the China market and all the driving forces. And AI and the data as any other countries, it actually become another powerful tool for the driving force as a driving force for the innovations. And a bit downside of the China market that I think we also encountered the economy slump and in recent years, particularly after the pandemic. And also we have some historical issues along with our development in the past decades. So the government also start to reforming our social structure and in terms of the populations allocations and also the developing industries. So all of this is, I think, as a very high level, what about the Chinese market. And I also put some of the statistics data at the bottom. As you can see, China already become the biggest patent filing countries and almost take half of the volume. And of course, I think in the past we do have concern about all these malicious filings and also we call so-called low-value patent filings through the patent office, China Patent Office. However, in recent years, the government also realized the issues and start to take measures to detain such kind of malicious filings. And therefore, I think overall, the numbers still reflect to some extent on the true generation innovations in China. And in another two particular industries, one is telecommunications. Um, I put the accumulative SEP filings in the past decades, and as you can see, although US still take the major portion of SEP filings, however, China is the second in line and also growing on the filings as well. And for pharmaceuticals, similar things happens as well. Um, China already become the second largest for the brand drug innovations, and this is continue happening. I think by the statistics last year, the pharmaceutical BD deals by number and by volume, China has taken the dominant position. That actually means a lot of biostocks um, actually attract the global investors and to reach a deal, to strike a deal and bring the product to the overseas markets. So with that in mind, I think when we talk about IP, there are a couple of things happening. As I mentioned, the government start to realize IP become one of the crucial factors for the society. So from the policy level, the Congress and the governments put put IP as one of the key factors in the next 5-year plan. And they start to, I think they give a lot of details, couple of highlights that the government start to promote more on the innovations and emphasize in the innovation is the driving force for the industry. And of course, that also lead to the profitability and for the companies. And the government also emphasized the IP protection and also data protection as well. So we start to recognize data as intangible assets and to try some of the mechanism for the protection regarding data as well. And on another side, since the technology goes so fast, and we start to take closer look on the regulatory control, which reflect on the tech export control and also, for example, human generics in resources control as well. And down the stream, for the legislations, we see more frequent amendment on the law and the regulations related to IP issues. And the courts also start to issue more judicial interpretations to further enrich the law and the regulations regarding certain issues. Another part is that the judicial branch continue to do the reforming, and we start to see new setup on the IP tribunals at the lower level, and the establishment of National Appellate Court for IP has been discussed for recent years. I think this is also something as a next step probably gonna happen for to further reform the judicial branch. And for the practice, when we see the different authorities under the government, CNIPA still focus on the prosecution, and some are more focused on the antitrust. I won't go through one by one, but I think overall, all these administration bodies uh, take take their steps to issue more detailed guidance or regulations regarding certain issues. And one thing I also want to emphasize is about arbitration centers. I think um, including the international arbitration centers and also the domestic ones, we all start to take take more initiative into the IP disputes. And for China, they also start to try to utilize the arbitration center as a mediation hub to kind of like split part of the IP disputes before the court and to lower the court's burden on the workload on the field. So this is a couple of the disputes. I think in recent years, the IP disputes volume gonna remain high, and as you can see, over the past couple years, the cases number constantly growing higher and higher in terms of civil litigation and also administrative enforcement. And overseas battlefield also become heated. I took the US as an example. As you can see, there are cases involve both Chinese entities sue each other, and also Chinese entity become the plaintiff to file the litigation against others. So also the number goes higher in like 30% in 2024 compared with last year. Um, sorry, the previous year. And in terms of damages, as you can see, in the past years, the damage award goes higher and higher, and we particularly pick up the damage award above 1 million RMB as as an example. As you can see, the trend is clear. The court are willing to award higher damages, and the percentage for the cases get above 1 million damages award is increasing as well. So this is actually also reflect the court's position. They want to recognize, the damages in patent cases have been quite low and probably not truly reflect the value of patents. So they start to take measures to increase the number and to reflect the value of patents. And the punitive damages have been introduced in China a couple of years ago. So as you can see, although the case volume is still very quite low compared with the huge disputes volume as I approach on the left up, but the trend is clear. The case volume goes higher, and also in terms of the damage award is actually jumping almost 30% from 2024 to 2025. I think from the justice message, I think that trend will not stop. The court will try more on punitive damage to further deter the willful infringement. Okay, when we talk about the big pictures, I do want to make a couple of the pairing to as a case study to reflect what's going on and about China. So a couple of cases offer for sale. This is more on the pharmaceutical field. So in A-side versus Qilu case, this is the issue for the case is about whether filing application for volume-based purchase is constitutes as a patent infringement. Unfortunately, the court found no, the border exemption should be applied, and there's no infringement for this application. And in parallel, at the same time, we actually represent Sandoz versus Hansel case. And for that case, eventually, we won way all way along to the Supreme Court, and eventually the Supreme Court said no. Although ASI case already becoming effective, but Supreme Court finally conclude that no, filing application for VBP does constitute offer for sale infringement, and this become a benchmark case and cited by the follower market players when VBP get involved in the IP disputes. Another case is MSD versus Hack. This is related to the listing on the National Reimbursement Drug List, which is one of the pre-step for VBP. However, for that case, which is also in parallel concluded by Supreme Court, um, to the contrary, the Supreme Court found out no, this is actually not constituted as an infringement. So I won't go to the details on the rationale and the reasonings from the court, but if you are interested, you can take a detailed look at the comparison. For combo use, as I mentioned, in China, service type claim is still applied for pharmaceutical use patents. And I give a like example of what is service type means for the audience who then familiar with the pharmaceutical patents. So basically, this means a use of a combination of drug X and plus drug Y in the manufacture of medicament for treatment of a disease. So this is the drafting approach to avoid non-patentable subject matter, namely the treatment of disease, which is not patentable in China. So in historically, when we talk about the combo use, this type of claims usually will not even pass through the prosecution. So usually the CNIPA gonna recognize this is a treatment of disease. Therefore, the patent will not get granted, or they consider this is no inventiveness for the patents and so whatsoever. So in Chugai versus the Livelong case, the CNIPA eventually recognized the patentability of combo use. They said, although treatment of disease shall be applied for use patent if they talk about features not really relate to the use of the drug itself. It's more like the administration of the drug when during the patient treatment. That would not be patentable. However, they do recognize combo use as an exemption from this type of treatment of disease territory. They recognize the combo use have certain inventiveness to the industry. Therefore, it should be patentable. And however, when we talk about the enforceability, Beijing IP Court actually recognized at the first time they said that combo use is something should be recognized and can be enforced against the generics. However, when we come to the Supreme Court overruled the decision and saying they should be strictly interpreted the claims. Therefore, because you have to have two drugs in the combination, or formed in the package, or formed in the single drug, to be recognized as a combo use. So therefore, this combo use issue still become a critical one and unresolved before the court. The doctrine of equivalence. This is another topic has been debated and tried before the courts for years. And for that one, in recent cases, the court found out the value, even outside the claimed number range, still could be considered as an equivalent. However, in another two cases, the Angeline versus Great and the Chugai versus Haihe, Angeline case, they mentioned that if this is a technical solution had been known to the market, when the patent was filed. However, they didn't claim in the patent that in that case there's no equivalent should be considered. And for Chugai versus Haihe, the Supreme Court actually overruled the precedent case law, saying the claim amendment without a express waiver would be lead to the donation principle, and therefore, um, since the feature has been donated through the amendment, therefore the doctrine of the equivalent have no space to apply. And indirect infringement. It's also quite often happened in various industries, particularly in the auto industries. There are a lot of parts going to be supplied to from the upstream to the final product. So a couple of the cases in Novartis versus a domestic company, the court finally recognized, one of the intermediates which used to produce the final API of the drug, the court found out, the API would be considered as an infringement if the the intermediate would be considered as an infringement if it's lead to the manufacturing of the patented drug. However, they also carve out saying, uh, it's also because the intermediate have other use, so it could be carved out for other applications which consider as a non-infringement. And there is an implement authorization use. So in the Burton versus pinball case, the court found out since the patentee doesn't doesn't specify, the product should be the bonding would be uh, expressly only suitable for the particular boots, and they actually selling the product separately to the market without saying any restrictions. In such case, the court saying, okay, there is an implement authorization to the market players and also to consumers. Therefore, for the bonding manufacturers, they are allowed to sell their product with as an implement authorization from the patentee. ICP issues, I think this has been talked a lot recently. And for this one, the ZET was a Samsung case. China, Germany, and UK, they all actually issue their judgment regarding the global royalty rate, and there are differences. There are significant differences on the numbers. So for the audience who are interested to see the detailed rationale analysis, and happy to dig on the cases and judgments. This is a huge topic. We can spend a lot of time on it. So I just want to touch base and we'll not go to details. And for the trade secret, another topic has been tried in many cases in recent years. I want to particularly address one issue, when the trade secret actually embodied in the product which commercially available to the market, how that trade secret will be recognized as a information going to be recognized as a trade secret before the court. In Sisters versus LabThink, in that case, the court saying that, if you have a confidentiality label and you have a warranty restriction saying you cannot open the product to see the detailed instructions inside of the product, all of this are not efficient as a protection measures to keep your trade secret embodied in the product. However, in Geely versus Walmart case, the court saying that although the car can be reverse engineering to see all the detailed structure and the arrangement and the measures of the components, however, they cannot accurately reflect the complete set of the information claimed by the trade secret owner. So therefore, reverse engineering wasn't a sufficient defense in this case. And when Sisters versus LabSync case was issued, the judgment was issued by Supreme Court. We also have a parallel case in the similar situation tried before the court. I think the court eventually also recognized, all the informations carried by the product could be considered as a trade secret. The key probably gonna be laid on what's the carrier for the trade secret, and that would be something uh, become a crucial factor for the court to consider. Another thing about damage calculation. For damage calculation, which has been a pain in China IP cases for a really long time. So as I mentioned earlier, the court start to pay attention to that issue, and in a couple of the cases, in Huiping versus Heng Lilong, in that one, the court actually takes the initiative to consider the price erosion on on the right holder's product and the market share loss uh, as a calculation for the damages. And in Jindiao case, the court also recognized, if the product is manufactured basically rely on all the claimed trade secret, then the contribution of the trade secret could be considered as 100% when we calculate the damages. Benefits enforcement, which also another particular debate issues in China. One thing is that I would like to read two issues. One is that inconsistency in claim construction, because in China, invalidation and enforcement proceeding are usually separate. One is tried before CNIPA, one probably tried by lower patent officers or by the court, which, these two proceedings are not really oftenly interact closely with each other because the authority are separate. That gave the space for the patentee to make, in some cases, completely opposite claim construction before the different authorities. And as you can imagine, for the invalidation, they try to make a narrow interpretation, and for the enforcement, they try to use a broader interpretation for their claims. So in Shengheng versus Huana and also Huamei versus CNIPA case, the court try to use a procedure approach to address this issue. So once the invalidation and also the enforcement come to the end, to the appeal stage, and they all come to the Supreme Court to try the case. And when that happens, the Supreme Court say, okay, I gonna try the case together with the same panel, and in that way, the panel gonna hear the debates from regarding both proceedings from the patentee at the same time. So that would restrain the patentee give contradictory claims and constructions. And another approach I didn't put cases here is that they also try to use a joint panel, meaning the court probably gonna who gonna try the case gonna host a joint hearings with the CNIPA who gonna try the invalidation. So in that case, they're gonna try the invalidation first, and the court panel gonna audit the hearing, and later on, the role gonna switch. The court gonna host the hearing for the infringement, and the CNIPA panel gonna audit the hearing as well. So in that case, both channel gonna hear the information, the debates from the parties, and try the case, give the rulings afterwards. Another issue about IPO. So IPO is an approach for many of the startups to go to the capital market. And that's become we call it a pre-IPO ambush. Probably our US audience can also very quite familiar with this tactic. So in the LeanWill versus Unitree case, the patentee actually filed the enforcement before the Unitree go to the IPO, and they did a couple of the funny things. and including amend their damage claims during the trial, and to avoid the lower case filing fees, and later on increase their damages to put pressures on the defendant. So the Supreme Court later eventually found out the plaintiff had a bad faith for the enforcement, just try to ambush the Unitree for their IPO and try to get some benefits from this patent enforcement. And later on, Unitree also filed a counterclaim against the patentee for the malicious lawsuit. And then eventually, the court also awarded damages to Unitree for against the patentee. Excuse me. Post-filing data, a very big topic in the pharmaceutical industry, and I do believe this also extends to other industry as well. So I won't go to the details. So at the two bottom case, top case, CNIPA actually rejected post-filing data for various reasons, saying, the one of the key is that they claim the technical effects are not really disclosed in the specification. Therefore, the post-filing data shall not be accepted. However, later on in recent years, Supreme Court say no, this is too restrict. So in University of California versus CNIPA case, the SPC say the post-filing data should be accepted based on the two factors, the positive factors and negative factors. And I do want to spend more time on the Novo Nordisk versus CNIPA case, which just released this year at the end of last year. So SPC says that actually accepted the post-filing data, which Novo Nordisk tried to improve the inventiveness of their drug. And I think the message is clear. The Supreme Court actually accept much broader recognition on the disclosure, what has been disclosed by the sophistication, and based on the probability testing factors. And I think, as you can imagine, this actually also linked to sufficiency issues as well. And again, because sufficiency is not a unique issue in pharmaceutical industry, so I would say this probably gonna expand to other industries as well, particularly for example chemistries. That's pretty much about all the cases I want to share. I hope the contrast can bring some can demonstrate the involvement of China practice. I think for the future, the innovation and the competition gonna continue to grow in this soil, and the court and the government gonna continue to recognize the IP value, particularly for patents and trade secrets. So which lead to I wouldn't surprise they're gonna have a new record high damages award for the cases, and the complex issues gonna continue to emerging. I think for patent similar things, and particularly although I won't touch base on copyright on AI much, but I think that would be a more interesting field to bring more complicated issues before the court for debates. And the cross-border disputes gonna continue to increase, particularly even for domestic companies. They probably gonna file the lawsuits in US, in Europe, because this is also the major market for the business. China tried to be a preferable forum for the disputes. However, I think that's going to be a long way to go for various issues. Reasons I will talk about couple of them in the challenge section. I do believe China need to explore the establishment of a national IP appeal court, because that would be further expand the manpower for the judges, and that could be address a lot of issues. So challenges. I think a couple of the issues have been criticized, and I would say that will be take time to resolve. Low transparency means a lot of judgment will not be published before the platform. So therefore, for the practitioners and the market players, they have very limited resources to know what's going on regarding IP cases, and that would be the backfire to us for the improvement on our protection system. And because the huge workload, as you can remember, the huge volume of the cases and the limited manpower before the court, so there are significant delay on the trial. And in term of the examination period, about the trial period, and also in terms of the trial quality. So that will be remain as a huge significant issues in China. Low utilization on the interim remedies, including preliminary injunction, evidence preservation, asset preservation, all of this are gonna remain at the issue for various reasons. And damages have been touch based. And again, another thing is that the market in developed quickly and the innovation generated on the daily base, particularly empowered by AI and data. However, for the authorities, for the law, and for the courts, it's gonna take time for them to realize what the market actually needs. And sometimes they still think we are the followers rather than the innovators, and that's actually gonna be reflected on their judgment. And the legal talents are in short. So again, AI doesn't help. So a lot of graduates consider have a little faith on the future career development. So they are very hesitant to enter to graduate to become a judge or become a private practitioner. So in that sense, we are very short of talents for future cases. And political intention and also uncertainty is going to remain as an issue for IP disputes. So that's gonna, I think, again, I would say nationalism also affects authorities' judgment to some extent when the geopolitical intents become geopolitical intents become intensive, and then the court may take a different position for their rulings. Thanks, Dr. Hao. Let me
Uh,
see.
Thank you so much, Binxin. That was just amazing. I realized how actually daunting a challenge we have given you because so much has been happening during the past few years, and it's just virtually impossible to, talk about Chinese IP current landscape in a comprehensive way. But within such a limited time, you certainly covered a lot of grounds, which actually, by the way, reminds me of a conference I just attended a few weeks ago. A China
Mhm.
observer told us that he said that whenever I'm trying to draw a conclusion on China, I feel like that blind person feeling a giant elephant, like different parts, I touch they if you touch different parts, you might be prone to drawing different conclusions, and these conclusions may not be coherent with each other. So, and
Mhm.
certainly, I think that's why your comprehensive introduction of when it comes to Chinese IP protection, patent and trade secret covers so much ground is very valuable to us. But before
Thank
I
you.
open the floor to audience, I'm sure, I mean, they have questions. I want to quickly just clarify a few places because maybe
Mhm.
our audience and both today and future audience, maybe they have different familiarity levels with Chinese IP. So let me just maybe clarify a few places. I don't know if you maybe firstly go back to the offer for sale
Okay.
slide, and you show the difference in different courts regarding whether VBP volume-based purchase that constituted offer for sale, right? So, and there seem
Mhm.
to be differences in the different courts, but
Yeah.
I wonder, what's the you don't have to illustrate in the details, but quickly maybe some reasons like or what is the current law then? What's the takeaway from this then? I know it might be difficult. If
No, no, it's actually this is a becomes straightforward. So,
okay.
although it's a case is an infective judgment, however, Sandoz case was concluded by Supreme Court, and in short,
Hmm.
filing a application for VBP will be an infringement.
Okay. But
So
at the same time,
that's the takeaway. So
okay.
yeah.
But at the same time, it's also this SPC that filing application for listing in NRDL, the National Reimbursement Drug List. This might be
Mhm.
a detail, but that's not considered offer for sale. Oh, I wonder about the reason.
Correct. So the reason is this, because when we talk about VBP, is actually the generic, usually going to be the generic, right?
Right.
They actually filed application to sell their own drug, their own generic drug to the network, to the hospital network. So in that way, the court consider, okay, this is clear, you are promoting your own product
Mm,
before your customers. And therefore, this is clear, satisfy all the factors regarding offer for sale.
mm,
And we didn't have any hurdles from the first instance or from and the appeal. So all the two courts actually recognize the same. Um, for the NRDL, the drug list, the reimbursement drug list, the court take a different conclusion because the court saying that the generic filed application is only used the API name or the generic name of the drug, not only not generic brand drug name.
okay.
And in that way, so this is a name, this is a chemical name gonna be used for either the brand drug or the generic drug. So it's a general name. And
Okay.
in that way, they consider, okay, anyone can file it, and there's a less consideration as a promotion for the generic's own drug.
Good. Okay.
So,
Yeah.
however, I do have a different position on this conclusion, on judge conclusion regarding infringement. But nevertheless, this is where we
This is
are.
well. Okay. Yeah. Good. My second question regards
Hmm.
the much bigger issue as you mentioned, the post-filing data.
Yeah,
Uh, so if you could quickly, yeah, I think it's here. So because the Novo Nordisk case is so important, and my own understanding is actually is built upon this case in the previous year. You listed here, which the final number 287, the SPC basically articulated this two-step test,
yeah,
including both a positive condition and negative condition in order for
yeah,
the data to be included. Then on top of that, this very recent case, I mean, recently released, Novo Nordisk just went one step further, saying
yes,
that regarding inherent implicit disclosure of step one, the positive condition, right? So meaning, could you illustrate a little bit, on this because this is so important. Yeah, so important. So maybe illustrate
yes.
a little bit in light of the facts of Nordisk case.
Certainly. Um, for both cases, actually, it's go with the inventiveness,
Mm,
and I think let me go with a little bit details on the Novo Nordisk case. So for that one, the patent mentioned a whole group of uh candidates, well, not chemicals, drug candidates, right? And they mentioned, okay, this is a GLP-1 drug. and for diabetes. And so when we go down there in the specification, they mention, okay, well, we need to do test, right? So we tested on the rats, lab rats, and later on we also gonna test on the mini pig. So in that way, we can see how long the drug can last in the animal body.
Right.
So which is one of the key effects claimed by the patent. So in that way, in that application, however, there's no clear experimental data directed to any of the specific compound. Okay.
Right.
Um, then when we come to the evaluation, uh, the CNIPA actually exam the specification and conclude that, okay, so since you only gave a general description regarding what kind of experiment you're gonna try on all these candidates, however, there's no concrete data written in the specification. Therefore, this technical impact you are saying, the long-lasting impacts will not be considered as described or disclosed in the specification. And therefore, they actually CNIPA reject all the post-filing data. However, when the case appeal to the Beijing IP court, the Beijing IP court says, hold on,
Mm.
from the rats data, actually Novo Nordisk submitted before CNIPA. All this data actually generated before the filing date. Well, before the priority date actually for the
Mm.
patent. Um, which actually echo back to what's described in the specification. Therefore, all the data should be considered. For the mini pig, they consider, however, all this is relatively, as you can imagine, this is first you need to do the rat testing, and then you go with the mini pig. However, when we go with the mini pig, there's no clear description regarding how you run the test on all these candidates. So therefore, the Beijing Appeal Court said, oh, no, all this post-filing data regarding the mini pig
Mm.
is not really because the lack of a sufficient description or disclosure from the specification. Therefore, all the post-filing data regarding mini pig shall not be accepted.
Mm.
However, when the case go to the Supreme Court, the court saying like, uh, I think basically, in short, long story short, the court saying that, uh, based on the context of the specification, as you can see, of clearly the patentee run the candidate's drug through the rats and then through the pig. And then they actually also mention, what's the criteria for the move on to the next stage of testing and screening. So therefore, eventually they think the courts conclude that based on the context, I think in general, based on the context of the specification, the long-lasting effects
Mm.
should be considered as disclosed from the specification. Therefore, all the data should be accepted from Novo Nordisk. So as you can imagine, I think from this case, the court, as you said correctly, the court move forward further from the University of California case,
Right.
saying, okay, not only the two layer of testing, actually, I think in short, it's go with a little bit more objective, about
Right.
less objective. Sorry, well, yes, less objective on the examination, what has been disclosed in the specification. So that gave a lot of space
Mm.
for patentee to argue.
Right.
And in short, that's also the reason when we try to draw the conclusion on what's the learning or takeaway from Supreme Court, is
Mm.
that probably there's a very broad recognition on the disclosure from the specification. And as like I said, as although this is addressed to the inventiveness issues, in
Mm,
this case. However, as you can imagine, disclosure is an issue actually linked to the sufficiency. So how the court gonna set
implement,
sufficiency
right.
standard would be quite relevant. I
Mm,
wouldn't say the case definitely gonna set the bar to sufficiency issue.
mm,
However, I wouldn't be surprised this would be cited as a
right.
defense for the patentee.
Very interesting to, keep observing in this field, post-filing data. Um, I do have a few questions for you to clarify, but I see our
Sure.
audience has one question now, so I'm gonna read it now. So to address, oh, it's from Sasmita. She's like you. She's a Berkeley graduate too. She was in my
Ah,
AI and IP
that's
course.
fantastic.
Very good student last year. So she said that as copyright frameworks globally, including recent developments in China, such as court decisions and policy discussions recognizing AI-assisted works, whether sufficient human creative input seem to be moving toward a meaningful human intervention standard. Do you see patent law evolving similarly on AI-assisted inventorship? I think she means in China. So,
Mm-hmm.
in particular, how should courts and patent offices approach situations where a human frames the problem? I love this. Selects or refines AI generated outputs, but the AI materially contributes to the inventive concept. It's a very, very good question. Um, yeah, Binxin, what's your observation in a Chinese context?
Yes, yes. Thanks for the question. I think this is a very important but very tricky question. Let me try to answer from my observation.
Mm,
I think um, the government also CNIPA and the court already recognize AI actually start to apply it in many industries and to accelerate the innovations. So therefore, actually, CNIPA also recently issued their guideline regarding AI-assisted inventions,
mm,
how they should be recognized and patented uh, under the uh, uh, under the legal framework. Um, However, in terms of inventorship, AI will not be recognized as an inventor of the patent. So that is a clear signal, and I wouldn't say that gonna change for the near future. Um, However, I do see a more tricky issue as Susmita mentioned. I hope I mentioned your name correctly. If not, excuse me. Um, so whether AI is materially contribute to the invention and how much human contribution is involved in the invention is a very tricky and complicated issues. I would say, for example, in let's took uh pharmaceutical industry as example. So as particular for small compounds or for big moleculars, you can use AI to do the screening. You can use AI to do the protein structuring. So therefore, there we already have the drug generated by AI using AI tools. So in that way, I think in short, um, to keep the patent patentable before the authority, uh, the 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 um the lab record, particularly what the scientist has been discussed and tried, explored, positive results and negative results, need to be more carefully recorded to reflect the human contribution on the drug generation. So this is something I would say probably going to become crucial. And of course, I think with the development of AI technology, I would say the human contribution gonna be less and less. And in that way, I would say the authority standard probably gonna be involved accordingly as well. But again, that potentially there could be a gap. So to recognize, the crucial human contribution to the whole invention. But how that goes to the extreme it's a hard question. Maybe by that time we don't need a patent anymore.
Well, it's a fascinating answer you give, actually, because this is one of my most passionate fields, research field myself as well. I apologize, Asmita. I mean, of course, we talk a lot about this. I mean, and my own view. I agree with most of what you said, Binxin, especially, with how mostly it's the CNIPA, not the Chinese courts there. We haven't seen too significant case regarding AI assisted invention and patent
Mhm.
in the Chinese court. But CNIPA, as you mentioned, did issue some general guideline and currently may be experiencing like intense case studies. But I agree with mostly what you have said, except that I don't believe in the near future human beings' role will be totally, completely diminished. I mean, maybe you didn't mean that
Probably
either,
long
but
term. I mean, long term probably gonna be diminished.
I don't know. Like I wrote like two articles, one 117 pages, the other 45 pages to talk about why if we continue the large language model, this methodology actually is not going to change too much in a foreseeable future because well, I'm not going to bore everybody today with my own research, but the thing is that human being may still have a strong hold in the original or truly creative problem finding and framing. And then while AI could help to predict the solutions, on the other hand, human beings, we are still very instrumental in making the value judgment as the last step. So basically, I frame all this into problem finding and framing. I'm arguing that this kind of contribution is significant enough, but that's another story. I think to answer Sasmita's question, together with Binxin, is that similar to other jurisdictions, uh, China is experimenting intensely. I mean, not experimenting, but discussing this issue. This is a common, very, as Binxin said, it's a very difficult challenge. Like what kind of contribution or what is the level of contribution is significant enough for the human researcher to be qualified as the inventor. Yeah, but we have to stay tuned on this, and we're gonna continue to discuss this in two conferences this coming autumn. A little advertisement hosted by Berkeley Asia IP. One is the second Global AI and IP conference in November, and the other is the seventh Berkeley Tsinghua Transnational IP conference in October. I'm sorry, Binxin, you still have something to say on this. I cut you.
No, 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 Dr. Hao, thanks for the inputs. I totally agree with you. I think in the foreseeable future, I would say, I mean, I think the scientists, still have a lot of contributions, and I think, well, again, I think pharmaceutical is a very good example to observe the development of AI,
Very
for the
good.
invention generation because the AI need data is the foundation for everything. And for pharmaceuticals, because all the drug need to be tested, go through clinical trial. So there are tons of patient data, and which the quality is good, and there's no contamination in general. There's no
Actually,
contamination on that. So that's actually helped the AI.
Actually, I do have a question for you.
Go ahead.
I'm not sure if this is still your field. I mean, you seem very knowledgeable about this. I'm wondering about your clients
No.
because according to my research, up until the end of last year, 2025, there are already about more than 80 AI native drug discovery firms in China. Um, yeah, I'm
Yes.
just wondering if the training data of these companies, about the quality, because you just mentioned the quality of the data. Like,
Yeah.
do you know what kind of like data you usually, I mean, the range of data they use to train their models? I mean, just. to maintain the quality of the because not all training data, even in the field of drug discovery and life science, it's equal. I mean, AlphaFold, obviously, everybody knows that a big
Yeah.
reason for AlphaFold success is extremely high quality data, the protein bank.
Mm-hmm.
But
Mm-hmm.
when it comes to AI-assisted drug discovery, I wonder, I don't know if I mean, without touching your client's trade secret, a general observation, do you have anything to share there?
I I try to share a couple of the sense. I think in short, because historically for small chemicals, then every the bank of chemicals actually the crucial assets for pharmaceutical companies. So that's actually become, the the pool for you to screening everything, to try everything, to play along with for certain disease, right?
Right,
And then, all the data generated from the past experiments and testings would be the fuel for the AI to understand, okay, all these different structures, what that probably lead to. For example, we talk about oncology, we talk about cancers, right? So
right,
how they react to certain target, and all of that will be something useful for AI training. And of course, later on, you're probably gonna have patient data, and for the approved drugs, and also for the drug field at a different stage of a clinical trial. All this data is also valuable assets for the AI training, because that's something uh, may not be published may not be even fully published to the public. Therefore, that's also something the company can use to train for the AI tools.
right.
So that's also the reason, as you can see, a lot of even the big firms start to engage with AI companies, right?
Yeah.
And for their discovery. Yeah.
Right. Yes. We've seen plenty of that. Since we are already here, this is not actually what I originally planned, but Susmita asked this amazing question. So since we are here, let me ask one last question regarding AI and patents. Do you see, I mean, some of the AI native drug discovery firms using patented data to train their model? Patents, structures, a molecule, drug, you know, patented structures.
This part I'm not really aware of,
Okay.
but I think I mean, um, because for the AI company, you can buy data from different resources. However, if for various reasons, of course they can use the data from the patents, or from the academic papers, which actually probably contain more data than patents, to train their machine. However, this is something, I would say the quality and the volume of data is
Mm.
relatively limited.
Right. Yeah. I asked that because, I haven't heard many people, actually very few people talk about this yet, but I happen to know that some, companies they use patented,
Hmm.
structures to train. Of course, it's natural, right? And currently, according to my understanding, you might correct me, but either, I mean, both US patent law and Chinese patent law wouldn't see this kind of training as infringement, patent infringement. But that's another issue we can talk about in the AI and IP session. Um, yeah, that's just we have
No, not yet. No, we didn't see
not
any
yet, right?
infringement. Yeah.
Okay, so we'll come back to the. I haven't seen any new questions, so just let me finish the list of clarifications in your PPT. My third question, I think, is regarding the indirect infringement.
Hmm.
Um, I don't know if you can go there.
Oh,
Uh,
okay.
right, you did list this condition, the elements of indirect infringement in
Mm-hmm.
China here. Could you maybe just compare a little bit with the indirect infringement in U.S. patent law? I assume you are
Yeah.
familiar with, right? So that might help our audience to get a very clear picture of where we are in China here now.
Certainly. So we actually for the indirect infringement there's a long history of involvement in China. As I mentioned, so actually a little bit historical background as I mentioned in the carve-out case. So in that one, the intermediate has a multiple use, but one of use is patented, right? Down to the stream is a patented drug, lead to a patented drug. So in that one, the court say, okay, so the intermediate manufacturer, um,
Mm,
what you since your product have a potential to be used to produce a patented drug, therefore this channel will be considered as an indirect infringement. And for you, this is something actually also you probably should know. Therefore, they concluded it's positive on the indirect infringement. However, later on from the court, Supreme Court issued a judicial interpretation regarding indirect infringement. This is the element I list as the right diagram. So for that one, they say that the defendant must aware of the pattern or should aware of the pattern.
mm,
And another thing that is it's actually need to be resolved into the direct infringement. Therefore, direct infringement is the precondition for the recognition of indirect infringement, which is similar to the U.S. practice.
right.
And um, the next level, the third factor would be either the accused product is exclusively used for the patent exploration, uh, meaning they do not have any other use.
Mm,
Okay. And another alternative we call it contributory infringement. And another alternative scenario is that if the defendant actually proactively inducing someone to implement the patent, basically saying, okay, please use my stuff to produce the patented product. Therefore, this is going to be considered as an indirect infringement as well. So we call it the inducement infringement. Um, However, I think the tricky one is on the green C, the exclusive use. So
right.
because as you can imagine, many of the product probably have multiple use rather than solely for one patented product. In that scenario, um, that means it's gonna be very harsh to
Mm,
enforce the patent, right?
right.
And so after the release of the judicial interpretation, I think the court um, take a harsher approach, restrict approach for a couple years, and then later on, the court realized this could be too not really effective for the protection, and therefore they start to step back a little bit, saying, okay, substantial use. So if the product accused infringing product is substantially used for
Mm,
the patented product, then therefore there's a contributory infringement. So in other words, so if the Novartis case, the carve-out case at current stage, it probably will not be recognized as a contributory infringement unless we have something else to further prove the intention of the infringer. Because the intermediate has multiple use, generally have multiple use, and probably making the patented drug is not the substantial use of it. Um, so this is where we are. And I do see the concern of abandon the practice on carve out.
mm.
And however, I think that's probably the next involvement in this topic.
Okay. Very clear. Thank you, Binxin.
You're
My
welcome.
my my last sorry. Yeah, I just see another question, so I'll wait a little. This is another question. Oh, this is from Yaowen, also a very seasoned Chinese IP counsel. Actually, Yaowen said, I have a question for Binxin. You touched on arbitration in intellectual property. Based on what you've seen, is it actually working, particularly for SEP-related issues? It's a good question, not a good question. Yeah.
Yes. So, very good question. Thanks for that, Yalvin. I think in short, uh, we are still observing. So that's indicating, although the court try to promote the arbitration as an alternative channel to settle the case at the early stage before we go to the full trial. However, many of the cases they are not really willing to settle at the early stage because everyone thinks, the penalty think they are infringing, and the defendant think, okay, whatsoever, let the court decide, and otherwise, the damage probably low, and your patent probably can be invalidated, and for various reasons, the party may not be entered the mediation stage. So, in short, um, I see. I don't think they are. In short, I think for all the patent cases or for trade secret cases, I don't think it's work as the authority planted. So most of the cases still flush into the court and waiting to take the long trial period. Um, and another thing is that for SEP issues, I think that will be a different story. Um, at this stage, I think both the patent holder and also the implementers are considering this channel. And but again, because court litigation is a powerful tool for the negotiation. And I think at current stage, they are still waiting to go to the court to try to pressure the opponent. So in that way, I don't think arbitration will be a preferable approach to make a negotiation. However, I think um, both sides are considering this arbitration approach because the confidentiality and because the potential risk on the royalty, for example, on the royalty rating assignment, the conclusion. So overall, this is, I think, in general, ICEP field probably are more keen to explore arbitration than compared with other industries.
I agree. Yalan, actually, I'm curious about your thoughts too. I apologize. This is a webinar, so you can't speak, but maybe we'll talk later, and you can speak in our next conference. So, back to another issue. I just need a little bit, not clarification. You talked about it clearly, but I'm just want to ask a
Sure.
little bit more questions. Regarding damages, that's another very important issue. Uh,
Yep.
because I've been, always wanting to do like a strict, rigorous empirical research of how the damages in IP litigation in China
Mm-hmm.
has been evolving. But as you know, you talk about this in the challenges part, lacking actually enough judgments online. Let me put it this way.
Yep.
I can't do a rigorous empirical study. So I'm just wondering, I've been observing at BCLT and Shanghai Jiaotong Law School. We hosted a joint workshop on patent damages last summer. As you know, you were
Yep.
there. But your anecdotal observation in the past few years, did you see a meaningful increase of other methodologies in damages calculation? I mean, for the audience that's not familiar with this, so you want to talk about like there are several different methodologies. Lost profits now equals the same priority with infringing profit. Then the third would be the times of the royalty.
Yep.
And
Yeah.
then the fourth will be statutory damages. But as you mentioned previously, it was maybe 99% statutory damages. But now I did see, you show the substantial increase of the percentage of cases higher than 1 million renminbi. And I'm wondering, like, maybe a lot of those are not statutory damages. And did you see a meaningful increase in other methodologies in courts?
Yes, yes. I think the answer is positive. I do see significant improvement from the judicial practice.
Significant. Wow.
Yeah. The court usually the court gonna say, consider all the factors, therefore we fall into the statute damages, blah 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 blah. But now I think the court are willing to explore, to go with details examination. Starting point is parties' evidence. So they go closer, spend more time and take a closer look on parties' evidence, and then come to a calculation. So as I mentioned in the slides, it's actually the court take the position to do the calculation regarding the price erosion and also the market share loss, come with a number. So this is something we see more cases and more judges are willing to try, particularly when the party have a good material or good evidence to build up the foundation. However, I would say a couple of things. I think the improvement is quite significant. However, we still have a long way to go in couple of the issues. One about Sorry, step back. Before we talk about that, another thing I think as a demonstration on the improvement is the evidence admission. So in the past, like for example, expert witness or judicial appraisal report regarding damages probably will not be considered.
Right.
So, but now the court are willing, actually, as in the audience and you may already know, the court actually sent a message saying, okay, we start to consider, the expert witness report and also judicial report regarding appraisal report regarding the damages calculation. So all of this is actually a very clear signal the court are willing and also willing to take a relatively uh more uh, more tolerant approach for the admission of various evidence. Okay.
Yes, I see in many cases the economic expert
Yeah.
witnesses now are involved, especially in the standard essential patent cases.
Yes.
Yeah,
Yes, that's actually
you
the
rarely
starting
see
point,
one
right?
without, right? Yeah, and
And I think it is expanded to other cases as well.
yeah, right. And you did mention the price erosion, and that is a very sophisticated actually analysis as part of the lost profit,
Exactly.
Yeah, so
Exactly.
it's difficult really to assess that. So I see a determined or poised willingness by at least some Chinese courts.
Yes.
You know, Beijing, Shanghai, Shenzhen,
Yeah.
and others actually, they're much more willing to consider this very sophisticated methodology.
Correct.
Right.
Correct.
So
So basically, I think this similar to a couple years our topic on in a couple of years ago regarding case law. So I think for this part, this the starting point. We see the hope, and this go with a lot of good positive trend, and hopefully it's grow and become a more common practice before the court. Yeah.
yeah, I totally agree. But Binxin, for myself, I feel this is a really exciting period. As you said in the beginning, this is a great transition. Like China is transitioning from more like a IP recipient or implementers, users of new technologies into like innovators and IP
Yeah.
asserters, if I can use that words. And for various reasons, I don't know if there internationally there are as many people as 10 years ago interest in Chinese IP. But I think, personally, I think it would be a mistake to lose interest in Chinese IP. And this is really very exciting period. And my own observations,
Sure.
also from your PPT today, is there it seemed to be like two trends rising continue to rise during the past few years. One is that Chinese courts are continuing to strengthen IP protection, increase of damages, like pulling back from the over harsh standard for indirect infringement, expansion of doctrine of equivalence, and also the rising
Yeah.
flat royalty of SEP, and also the punitive damages. To be honest, I don't completely agree with all this. I mean, I don't think necessarily if it's strengthening or more damages or punitive damages necessarily mean it's good. But I do also see the second trend is that at least in many circumstances, Chinese courts are trying to calibrate better the IP protection with the technology's inventive contribution. And I'm particularly impressed with you mentioning the SPC, Supreme People's Court, and the CNIPA, and they're composing the same panel to make sure the claim construction are consistent on both ends, on the patent invalidation and patent infringement end. So let me ask you one last question. I mean,
Sure.
our time is running out. I'm sorry. Do you see this as a trend, or is this the joint panel by SPC and CNIPN to make sure it's consistent? Do you see it as a trend or as exceptional case?
I would say it's more like an exceptional case. So although
Okay.
the court tried to take an approach to address the issue, however, I think procedurally, uh, procedure-wise, excuse me, it's hard for the case when they appeal. It's going to be eventually at the same time meet each other before the Supreme Court, and when we see the joint hearings again. For the court, they are usually sitting in one place, and CNIPA sitting in Beijing, and so it's take time to arrange the schedule.
Mm.
I do hope, because right now we have the virtual meeting, we have the virtual hearings, so it's much easier to conduct remote hearings from the authorities. Therefore, it's better. I do hope they can use the virtual meetings to have a joint hearings between the court and the CNIPA. However, I didn't see that happen
We'll keep
often
watching.
before the authorities. And I do see, although this is probably one approach to go, I do hope there are cases the court gonna condemn the patentee for such kind of
Yeah.
misbehaviors. And that probably could be another, we have the malicious lawsuits, and we have the good faith principles. So I think the court may be able to use it as a
Mm.
tool to deter such kind of behaviors. Yeah.
Okay. We'll stay tuned. Thank you
Yes.
so much, Binxin, for your wonderful presentation and taking your precious time to chat with us. And um,
Thank you.
yeah, thank you, our audience who stayed up until the last minute, and also very importantly, thank you, Justin. Um, you've been great. You've been the best, actually. Thank you,
Thank you,
everybody.
everyone. Thank you
Okay,
for the time. Take care.
have a great day.